Imagine with me for a moment that you are the proud owner of an e-commerce business, and the name of your company is Smoking Everywhere, and your principal products are electronic cigarettes. I'll aid in your imagination. I grabbed a screenshot from your website. Like a lot of e-commerce companies, one of the ways that you generate leads is by entering into affiliate relationships with other website owners. And the way these relationships work is you enter into a contract with the owner of another website. They agree to send web traffic to you, and you agree to pay them a commission every time someone buys a product on your website after coming to your website from theirs. And you entered into just such a relationship with a company called CX Digital Media. And this was an important relationship for you, and so you were careful to negotiate a written contract. And the terms of the contract, you'd pay $45 per referral, and there was a 200 customer per day limit that you'd owe referrals for. And one important part of the contract was that it could only be modified in writing. And this is a really common provision in contracts, and it's a protection for each of the parties. So if you think about the process of entering into a contract, I'm sure many of you have gone through the process. You focus your attention on the details of the contract, making sure all the terms are good. You probably pull in some of your key employees to get their input. You might pull in some trusted advisors, maybe have a lawyer take a look at the contract. And so at this point in time, you agree to the terms that you want, and you don't want those terms to be accidentally changed without going through another formal process. And so that's this provision in the contract that you negotiated with CX Digital Media contains this provision to protect you. So things with CX Digital go well for a while. They send you leads, you pay referrals, and then one day one of your key employees has an instant message conversation with one of the key employees from CX Digital. And the conversation lasts throughout the day. It's kind of intermittent, the way these things go, mainly talking about technical issues. But at some point during the conversation, the gentleman from CX Digital says, "We can handle 2,000 orders per day by Friday with your blessing." Of course, that's 10 times more than you'd agreed to. Your employee responds that he's away from his desk. "I'll be back with you." About an hour later, he responds, "No limit," all caps. And CX Digital immediately responds back, "Awesome," with an exclamation point. CX Digital sends you a slew of additional referrals and a very large invoice, wanting $45 for each of those additional referrals. You refuse to pay because you've got a contract that says 200 per day limit, and so they sue you. What happens? You can probably guess, because we're talking about this case, that you lose. So the court holds that this contract that had a provision in it, it's a written contract, provision in it says that it can only be signed or modified in writing, was modified by this very short, informal, instant message conversation. I can't think of a less formal way to modify a contract. I mean, IM, maybe text, maybe you could tweet a modification. I mean, how can you get less formal than that? Pretty scary. So now let's talk about emails for a moment. You might remember that there used to be a Discovery Channel store in Union Station in downtown St. Louis. Well, they went out of business in August of 2007, and that breached their lease. And so Union Station sued them, and then in September 2007, there was an email exchange that took place between the person who was negotiating on the part of Union Station and the person who was negotiating on the part of Discovery Channel. And so the Union Station gentleman says that basically, counter offers with $220,000, and then the Discovery Channel replies that we'll take it, basically. And apparently the settlement kind of breaks down at some point. Union Station eventually sues to enforce this settlement agreement, and the court held that it was a binding contract. And what's surprising about me is not that an email exchange formed a binding contract and that a court would enforce it, because that's very common. But if you look at don't know how well my red button works here. If you look at this last sentence here from the excerpt, it was clear that that Discovery Channel assumed that there would be more paperwork. The negotiation wasn't done yet. There was going to be a termination agreement that was to be negotiated in the future. But yet the court still held that this email exchange formed a binding contract. So let's take a look at the law behind this. Why are courts deciding these kind of things? A contract is a promise or set of promises that courts will enforce. And at the point in time when a contract is actually entered into, when the contract is formed, the relationship between the negotiating parties fundamentally changes. So before contract formation, you probably can walk away without any adverse consequences. But at that point in time when the contract is formed, everything changes. And another tenet of contract law is that offer plus acceptance plus consideration equals a contract. So we'll take an example to kind of flesh that out a little bit. So I've got a kayak that I want to sell for $400. So I say to Bill, Pranat, I'll sell you my kayak for $400. Bill's seen my kayak. He knows that's a heck of a deal, so he accepts. So we've got a binding contract. I made an offer, Bill made an acceptance, and the consideration is the promise of what each of us is going to bring to value, of value to the relationship. So in my case, it's the kayak. In Bill's case, it's $400. Now, I didn't bring a kayak with me, and Bill, you probably have $400 in your wallet. So although he could do it now, I didn't bring my kayak. So we decided that we'll meet tomorrow. I'll bring my kayak, you bring your money, and we'll have a closing. But Bill wants, even though he knows it's a good kayak, he wants some warranties, make sure it doesn't leak. And so we've got terms and conditions that we negotiate, and we're going to put it in writing. Now, as you're probably aware, you've all experienced this. This is kind of the typical way that business contracts are formed. You negotiate, and then you sign it. Now, in 1999-2000, Congress enacted the federal e-sign law, and the states started enacting the Uniform Electronic Transactions Act. And what these laws do is they make electronic signatures equally enforceable as physical wet signatures. This is wonderful for commerce. I mean, that's why you can order stuff on the internet, because your electronic signature is binding. So it's very helpful. But as we could see from the IAM conversation that modified a written contract, and as we could see from the email exchange that formed a contract maybe before one of the parties thought they had a contract, there also are potential pitfalls for this. So here's a couple of tips so you can protect yourself. The most important is to be aware of this. I mean, in your communications, whether it's email, whether it's texting, whether it's even IMs, with your communications with your business partners, maybe a vendor, maybe customers, you should be cognizant of the fact that your communications could have implications as far as contracts. They could form a contract. They could modify an existing contract that you have with these folks. So be cognizant of that yourself, but also make sure that you train your personnel to be aware of it. So anybody that's a key employee in your company that might be handling contracts or that could be construed as binding your company to a contractual arrangement or modifying an existing arrangement, be sure that they have proper training so that they can be careful about what they say. And one thing that you could do is when you're negotiating a contract and sending drafts back and forth via email, put draft on the document itself so that it's clear that you're not finished negotiating. You're not ready to reach that point in time when things are changed and you actually have a binding contract. And then one final thing that you can do is to improve your amendments in writing clause. I started out by saying that your contract with CX Digital Media had a provision in it that said that it can only be modified in writing. Well, the problem that you had, that you had with them could have been taken care of if that provision made clear that electronic communications and instant messages and those sorts of things can't be used to modify the writing. So electronic communications are wonderful. The fact that you can enter into contracts that way. e4e, the e-sign bill, they really grease the wheels of commerce. But you have to be careful out there. Your informal electronic communications could have major implications to your relationships with other people, so you have to be careful. And I'll close with that and take any questions you might have.
We're going to get the questions on mic, so we have on video.
Please.
Brian, does the law recognize the concept of authorized agents? Example, you might have a sales rep or a customer service rep who makes some sort of statement via email that could be construed as an amendment to a contract. Are you protected if in the original contract you designate authorized agents, that only designated people can amend said contract?
Yeah, definitely. That can help. So basically, two kinds of people can bind a company contractually. One is people who actually have authority to do that. So they've actually been authorized. And what you're suggesting, Tom, is that you can let people know, the counterparties to your contract know who those people are by actually listing them in the contract. And that also protects you from the second group of people, and that's apparent authority. So if the way that you do business can create the impression to the market that somebody has authority to bind your company, and that other party relies on that, then you could actually be bound by that person's actions. And so if you say in your contract, only X, Y, and Z people can amend this contract, then that kind of takes care of the apparent authority problem. Yes, sir.
Yeah, I'm assuming you can protect yourself by adding a signature line to everybody in the company with some sort of disclaimer saying that anything in this email is not part of any binding contract, or you see that a lot in public accounting firms and law firms.
Right. Yeah, and that is a tactic that a lot of people use. It can be effective. One problem with that is when that disclaimer is automatically placed on your email, every email, even your emails, with your spouse. I'm going to pick up something from Target on the way home. This is not a binding contract. It really calls into question whether you really intended that for that particular communication. So, but that is something that is very commonly used. So.
Brian, I think a lot of people in the room put proposals together for clients. This is what I'm going to do, and client says, well, write that up and give that to me. And then later on, maybe I did what I said I was going to do, or maybe I didn't, and I have this thing in writing that said I was going to generate additional leads, and here's how many leads I was going to get for you and all of that, and I don't deliver. Am I in the situation that you described here with a proposal?
That's a good question. Really, what it comes down to is whether the proposal is an offer. If it's an offer and the other party accepts it, then you've got a binding contract. And so whatever was part of that offer, you're bound to do. Now, an offer is, to get a little bit more detailed and technical about what an actual offer is, it's a communication from one party to another that the other party, not the other party, but that a reasonable person objectively would assume your offer puts the power of contract formation in the other party by accepting. So that's an awful convoluted way to say that. But so if you want to be bound, then you can be clear this is an offer. If you don't want to be bound, you'd be better off with some language in there saying this is a proposal, it's not an offer, and you can't bind us contractually by just accepting. So, anybody else? All right, thank you.